Welcome to today's deep dive. We are really thrilled you could join us. Have you ever stopped to wonder who actually owns an idea?
Right. Not a physical object you can hold in your hand, but the intangible stuff.
Exactly, like a song, a brand identity, or even the code powering the applications you use every single day.
It's a massive question.
It is. And today we are acting as your personal academic guides to unpack a document that answers exactly that. We're looking at the Paper v. Intellectual Property Law syllabus from Osmania University's LLB program.
And, on the surface, an academic syllabus might sound like like a dry administrative roadmap.
Yeah, a bit dull.
Right. But when you look at the structure and the specific topics selected for these law students, you quickly realize this document is essentially the master blueprint for the modern knowledge economy.
It really is. It dictates who gets to profit from human ingenuity and ultimately who gets left behind.
Exactly.
So the mission of this deep dive is to map out the exact legal framework that governs creativity, innovation, and global commerce, using the syllabus as our guide.
And trace how the law tries to keep pace with the relentless speed of human genius.
Okay, let's unpack this, because the architecture of this course is remarkably ambitious. It sweeps from traditional protections that have anchored commerce for centuries, all the way to the absolute bleeding edge of modern technological disruption.
Yeah, it covers incredible ground.
Let's begin where the students begin, with Unit I, which focuses on the foundations and the frontier of the field.
So Unit I serves to define the vast landscape of intellectual property, or IP. It requires students to understand the meaning, nature, classification, and the ultimate significance of these intangible rights.
Which is a heavy lift for week one.
Oh, for sure. The syllabus neatly categorizes the field, starting with what it calls the main forms of intellectual property.
And these main forms are the pillars we're mostly familiar with. The course outlines patents for inventions, trademarks for commercial branding, industrial designs for the aesthetic look of a product, and geographical indications of goods.
Which is such an interesting one.
It is. That's the legal mechanism ensuring that a sparkling wine can only be called champagne if it actually comes from the Champagne region of France.
Right.
And finally, it covers copyright and neighboring rights. For those of you who might not follow the nuances of music law, neighboring rights are what protect the performers and the broadcasters, separate from the person who actually wrote the underlying song.
And that distinction alone shows the granularity expected of these students. But the syllabus doesn't just linger purely on the classics.
No, it does not.
It shoves the law student directly into the deep end with a section specifically dedicated to new forms of intellectual property.
Because the law is inherently reactive,
Exactly, and the section proves it. We see plant varieties protection and biotechnology in there.
forcing students to grapple with the patentability of living organisms and genetically modified agriculture.
Right. We also see computer programs and layout designs, which specifically addresses the topography of integrated circuits, the physical architecture of the microchips running our world.
The inclusion that really stands out to me in that section, though, is GRTK,
Yes.
which stands for Genetic Resources and Traditional Knowledge, including that alongside microchips and biotechnology is a powerful statement.
It really is.
It signals that modern IP law isn't solely concerned with protecting Silicon Valley tech giants. It's equally concerned with creating legal frameworks to prevent the exploitation of indigenous knowledge, like traditional medicinal practices that have been passed down for generations.
Which represents a massive paradigm shift in how international law defines property. But what's fascinating here is a specifically highlighted phrase sitting right at the very end of Unit I, Artificial Intelligence and Intellectual Property.
Seeing that explicitly listed in the foundational unit of a law course is incredibly striking.
Think about the implications for you as a creator or a consumer. It demonstrates that foundational legal education at major institutions like Osmania University is actively wrestling with how machine learning disrupts traditional ownership models.
Because it disrupts everything.
Right. Does a non-human entity even have standing? If an AI system independently generates a novel chemical compound for a new pharmaceutical drug, who actually receives the patent monopoly?
Is it the software engineer?
Or the corporation running the servers?
Or the user who typed in the prompt?
Exactly. By placing this right in Unit I, the curriculum is telling the next generation of lawyers that the established rules are fracturing, and they will be the ones tasked with rewriting them.
It sets a highly dramatic stage for the rest of the course. Once the students understand what constitutes intellectual property, they have to understand how those rights are recognized and enforced across the globe.
Because ideas don't stop at a border checkpoint.
Not at all. And that brings the syllabus into Unit 2, the Global Rulebook.
Right, because a patent granted in New Delhi offers zero protection if a factory in Leon decides to reverse engineer and manufacture the exact same invention.
Local statutes are just insufficient in a globalized economy.
You absolutely need an architecture of international agreements.
So Unit 2 is dedicated entirely to the evolution of international protection of IPRs, or intellectual property rights. The syllabus mandates that students trace a really heavy-hitting timeline of historical instruments.
Quite a list.
It starts with the Paris Convention of 1883, which was revolutionary because it established the concept of national treatment, meaning a member country has to grant the same industrial property protection to foreign citizens that it grants to its own.
Right.
Then it moves to the Berne Convention of 1886, which is something similar for literary and artistic works. That one notably established that copyright is automatic upon creation without needing formal registration.
And tracing those 19th century treaties gives students the historical context of how nations first attempted to respect cross-border creativity.
From there, the syllabus accelerates into the modern era. It covers the Madrid Agreement of 1891 and its crucial 1989 protocol,
which centralized the international registration of trademarks so a business doesn't have to file separate applications in 50 different countries.
Exactly. It mandates study of the WCT, the WIPO Copyright Treaty of 1996, which was specifically drafted to drag the Berne Convention into the digital age and address computer programs and databases.
So necessary.
Yeah. It also includes the Patent Cooperation Treaty, or PCT, of 1970, alongside various conventions under the World Intellectual Property Organization.
It is a dense, complex web of diplomacy. But if we connect this to the bigger picture, we have to look closely at the heavily emphasized portion of Unit 2, the TRIPS Agreement, 1994, and its impact.
TRIPS.
Right. TRIPS stands for Trade-Related Aspects of Intellectual Property Rights. For anyone listening who follows international trade, TRIP is the geopolitical anchor you simply have to understand.
Because prior to TRIPS, international IP protection was highly fragmented.
Very much so.
Enforcement mechanisms were weak, and developing nations often ignored the strict IP laws favored by industrialized nations. TRIPS changed the entire dynamic.
It was negotiated at the end of the Uruguay round of the General Agreement on Tariffs and Trade. The core mechanism of TRIPS was essentially an ultimatum.
Yeah, a massive one.
If a nation wanted to be a member of the newly formed World Trade Organization and enjoy the massive economic benefits of global trade, they were required to enact strict minimum standards for intellectual property protection within their own domestic borders.
It tied intellectual property directly to international trade sanctions.
Exactly. TRIPS transformed IP from a niche domestic legal issue into a central, non-negotiable pillar of global economic policy.
Which means the global rulebook mandated by TRIPS ultimately dictates the domestic legislation of every member nation.
Right.
And the syllabus follows this exact logical progression. It moves from the international treaties in Unit 2 directly into the specific Indian statutes enacted to comply with them.
Which lands the students in Unit 3.
Yes, Unit 3, which enters the realm of expression. This unit is an exhaustive study of the Copyright Act of 1957.
The curriculum requires students to understand the meaning, nature, historical evolution, and significance of copyright law within the Indian context.
Moving methodically through the salient features of the Act to determine what legally constitutes the subject matter of copyright.
Right.
Here's where it gets really interesting. The syllabus explicitly demands students study the idea-expression dichotomy.
Such a core concept.
It sounds highly academic, but it is the absolute bedrock of creative freedom. Since we know copyright protects artistic works, how does the law prevent someone from monopolizing a broad concept?
Well, the law draws a very sharp line. Copyright law categorically does not protect an idea, a procedure, a process, or a mathematical concept. It only protects the original expression of that idea.
So if you write a screenplay about a cynical detective solving a murder on a luxury train, you do not own the idea of a train murder mystery.
Exactly. Any other writer is free to use that premise. What you own is the specific dialogue, the unique sequencing of scenes, the distinct character traits, the tangible execution of the concept.
Beyond establishing what is protected, the syllabus dives into the strict mechanics of ownership. It covers the rights of authors and owners, the complex rules regarding how those rights are assigned or licensed to third parties like publishers or record labels, and the collective management of copyright.
Naturally, it also covers infringement.
Yes, but the syllabus places significant emphasis on a vital defense against infringement, the doctrine of fair use.
Fair use is essentially the pressure valve of copyright law. Without it, intellectual property would easily become a tool for massive corporate censorship.
It would stifle everything.
The law has to strike a delicate balance. It must grant the creator a temporary monopoly to incentivize them to produce art and literature. But society at large still needs the ability to learn, critique, parody, and report the news.
Right.
The doctrine of fair use allows you to utilize portions of a copyrighted work without seeking permission or paying a royalty, provided the use meets certain strict criteria, such as being for educational purposes, research, or critical commentary.
The unit then rounds out the structural components of the Act, requiring students to understand the authorities operating under the Act and the specific remedies available when infringement occurs.
And from the realm of artistic expression, the syllabus inevitably crashes right into the commercial battleground.
That marks the transition into Unit 4, which is dedicated to brands, domains, and designs, beginning with the Trademarks Act of 1999.
Right. Since we understand that a trademark fundamentally acts as a badge of origin to prevent consumer confusion, the syllabus skips past simple definitions and forces students to analyze the rationale for protection and the nuances of trade description.
A major focal point highlighted in the text is the distinction between conventional and non-conventional trademarks.
This is a fun area.
It really is. We are all familiar with conventional marks, the golden arches, a specific brand name, a distinct logo, but non-conventional marks represent the frontier of commercial branding.
They do.
The law has expanded to recognize that consumers identify brands through multiple senses. Students have to study how a corporation can legally trademark a specific color hue, a three-dimensional shape, a short audio jingle, or in highly specific circumstances, even a distinct scent.
Provided it has acquired absolute secondary meaning in the marketplace.
Exactly.
And expanding on that modern commercial reality, the syllabus heavily features trademarks and internet domain names.
Huge topic.
In the current digital economy, a company's URL is frequently its single most valuable asset. The legal friction between traditional territorial trademark rights and the inherently global, borderless nature of internet domain names is a massive area of ongoing litigation.
The syllabus also creates a deliberate juxtaposition by requiring students to study the concept of passing off alongside formal trademark infringement. These are two distinct legal weapons.
Passing off is a fascinating area of study because it relies on common law torts rather than statutory registration.
Right.
If a business hasn't formally registered their brand name, but they have built up significant goodwill and a strong reputation over decades, another company cannot simply swoop in, design a confusingly similar product packaging, and deceive the public into buying their goods.
Passing off is essentially the law preventing one party from misrepresenting their goods or services as the goods or services of another.
It's a critical tool for protecting unregistered brand equity against deliberate consumer deception.
Unit 4 then pivots from commercial branding to the physical appearance of the products themselves, bringing in the Designs Act of 2000. It focuses heavily on industrial designs.
The core of this section revolves around the registration of design. Students must dissect the definition and precise characteristics that make a design registrable.
Meaning it cannot be dictated purely by function.
Exactly. It must have aesthetic appeal applied to an article by an industrial process.
The syllabus explores the specific rights granted to design holders, the remedies for piracy of registered designs, and crucially, the intersection of copyright and design.
This is an incredibly thorny area of law.
So thorny. If a designer creates a beautiful, highly sculptural chair, is it a piece of art protected by copyright for the author's lifetime plus 60 years? Or is it a mass-produced industrial item that only receives the much shorter protection window of a registered design?
The syllabus forces students to navigate that exact overlap.
Which perfectly sets up the final and arguably most complex statutory framework in the course. Unit V brings students into the heavy machinery of the intellectual property world, the mechanics of patents.
Built around the Patents Act of 1970.
Yes, it opens with a conceptual and historical overview of patent law in India. The foundational hurdle for any student here is mastering what exactly constitutes a patentable invention.
And the standards are incredibly rigorous.
They are. An invention cannot simply be a good idea. It must be novel worldwide. It must involve an inventive step, meaning the advancement wouldn't be obvious to a person skilled in that specific technical field, and it must be capable of industrial application.
The syllabus requires a deep understanding of the different kinds of patents and the highly technical procedural steps required for obtaining one.
Recognizing the global nature of innovation we discussed back in Unit 2, the course specifically highlights the procedure for obtaining patents in other countries, focusing on the PCT procedure.
Right. The Patent Cooperation Treaty allows an inventor to file a single international patent application, rather than filing simultaneously in dozens of individual national patent offices.
Once a patent is granted, the syllabus outlines the immense rights and obligations of the patentee. The state is essentially granting the inventor a powerful, legally enforced monopoly over their invention for a standard period of 20 years.
But the syllabus immediately introduces a massive counterbalance.
It has to.
This raises an important question. If a patent grants a total monopoly over a life-saving pharmaceutical drug or a critical agricultural technology, what happens when the patent holder refuses to manufacture enough of the product?
Or prices it so astronomically high that the public cannot access it.
Right. The syllabus tackles this directly by focusing heavily on the limitations on patent rights.
Because the state never completely surrenders its authority, the syllabus explicitly lists the mechanisms the government retains to break a patent monopoly in the interest of the public.
Students must study compulsory licensing.
Which is the legal process where the government overrides the patent holder's exclusivity and licenses third-party manufacturers to produce the patented product.
Often invoked during severe public health emergencies to ensure access to essential medicines.
It goes even further. The syllabus mandates the study of acquisition of invention by government, where the state can legally appropriate a patent for public purposes.
It also covers secrecy directions. If an inventor attempts to patent a technology that is highly relevant to national defense, the government can issue secrecy directions, preventing the invention from being published or patented internationally, effectively locking it down.
It is a stark reminder that intellectual property rights are not absolute. They are conditional privileges granted by the state, and the syllabus makes it clear that national security and public welfare will aggressively trump an individual's commercial monopoly.
Absolutely. The unit then concludes by covering the infringement of patent rights and the specific legal remedies available to inventors.
To truly grasp the depth of what these law students are expected to absorb, you have to look at the final section of the document. The syllabus is grounded by a suggested readings list that is genuinely staggering in its academic weight.
It is a gauntlet of legal scholarship. They are citing the absolute giants in IP law.
The reading list includes P. Narayanan's foundational text on intellectual property law. It lists Rai Chowdhury's comprehensive work covering trademarks, copyrights, patents, and designs. We see texts by G.B. Reddy and the highly influential work of John Holyoake and Paul Tormans.
They include B.L. Wadhira's treatise on patents, trademarks, copyright designs, and geographical indications.
Alongside W.R. Cornish, who is a towering figure in British and international IP law, and V.K. Ahuja.
And impressively, Dr. Elizabeth Furkey has two separate, highly specialized books featured on this single reading list. One focused entirely on the law of patents, and another comprehensive text on general intellectual property.
This list proves that figuring out who owns an idea is an incredibly rigorous, multi-layered academic discipline.
These students aren't just memorizing statutes. They're being asked to synthesize decades of high-level legal philosophy to navigate a system that fundamentally shapes human progress.
So what does this all mean? We've covered everything from international treaties and the nuances of passing off to compulsory licensing and the idea-expression dichotomy. Why should you, listening to this deep dive right now, care about the structure of the Osmania University LLB Paper V syllabus?
Because the syllabus outlines the invisible architecture of your daily existence. When you choose to buy a cheaper generic medication instead of the branded version, you are interacting directly with the expiration of patent monopolies and the exact statutory limitations outlined in Unit V.
When you instantly recognize a counterfeit pair of sneakers online, you are engaging with the principles of trademark law, passing off, and brand goodwill from Unit 30.
When you stream a documentary or read an independent critique of a film, you are witnessing the delicate balancing act between the rights of authors and the doctrine of fair use detailed in Unit 3.
Intellectual property is the foundational currency of the modern knowledge economy. Understanding how it is secured, how it is enforced internationally, and how it is ultimately limited by the state is crucial to understanding how our society actually functions.
But there is a lingering tension built into the very structure of this syllabus, and it's something I want you to mull over. It's a paradox that builds on everything we've discussed today.
What's the paradox?
In Unit 1, the syllabus forces students to acknowledge the arrival of artificial intelligence. Yet in Unit 3, it rigidly outlines the idea-expression dichotomy and defends the strict rights of authors' frameworks designed entirely around human creativity.
The collision of those two concepts feels inevitable.
It is happening right now. If a modern generative AI model is trained on millions of copyrighted human expressions, books, source code, illustrations, to independently generate a highly profitable new computer program or industrial design, who truly holds the intellectual property rights?
Can a machine be legally recognized as an author?
Or is the AI committing copyright infringement on a massive, unprecedented scale? Perhaps it is fully protected under the doctrine of fair use because the machine is simply learning from existing works, exactly as a human law student would.
Wow.
The statutes from 1957 and 1970 were simply not built for autonomous creative machines. The brilliant minds studying this very syllabus will be the ones fighting in the courts to answer that exact question. The future of innovation depends entirely on how they rewrite these rules.
What a profound reality to leave on. The law is never a finished product. It is a constant, high-stakes debate. Thank you so much for joining us on this exploration of the Osmania University IP syllabus. We hope you walk away looking at every piece of technology, every novel, and every corporate logo with a much sharper perspective. Until next time, keep diving deep.